Our next case is People versus Stewart. This is also a 15-minute mini oral argument on the application. Welcome, counsel. You may reserve some of your time if we do not use it up. Good luck with that. And we'll ask you to do your best to keep track of your time, and you have 2 minutes of a free fire zone if you wish.
Good afternoon. May it please the court, and welcome to the bench, Justice Bolden. Justice Bolden. Okay. My name is Marielena David from the State Appellate Defender Office on behalf of Joshua Stewart. I will reserve 2 minutes for rebuttal. 2 homicide detectives interrogated 18-year-old Joshua Stewart for hours, beginning at 3:40 in the morning, while they cursed and yelled at him, insisted in his guilt, used degrading and threatening language, lied to him about evidence they had against him that did not exist, and they refused to let him contact his mom. Hours into the interrogation, the police made a false promise of leniency, suggesting that Josh would receive a significantly lower prison sentence of 2 years if he confessed, or 20 to life if he did not. Only then did Josh make a statement to police. And as Josh said in his own words, y'all talking about 20 or 2, who wouldn't take 2? This court should take the opportunity presented by this case to provide direction to trial courts that lies by police about evidence and false promises of leniency by police deserve special consideration in a totality of circumstances analysis. As pointed out in the Innocence Project and the American Psychological Association briefs, there's decades of scientific research and expert analysis that highlight the danger of these 2 specific interrogation tactics and the danger they have in significantly increasing the coercive nature of interrogations, especially for young people like Mr. Stewart. His statement was involuntary and inadmissible. Further, the court should strike down MCL 769-3410. In Lockridge, when this court determined that Michigan's guidelines violated the 6th Amendment in the same way the federal guidelines did, this court tracked the remedy imposed by the U.S. Supreme Court in Booker in every way except one, the continued validity of 769-3410. And since Lockridge didn't involve the appeal of a within guideline sentence, it makes sense that the court didn't address that provision at the time. That issue was saved for another day.
Counsel, I'd like to jump in on the interrogation issue. One of the things that I think most first-year law students learn is that trickery is allowed in interrogations. Where do we draw the line? I think it can't be disputed. This was sort of in that category when they were talking about the different sentences that he could face. But how do we draw that line?
So the difference between permissible trickery and conduct by police that's violative of one's constitutional rights can sometimes be a fine line. And so it sometimes may be difficult to draw that line. It's not difficult in this particular case because the key consideration for this court is considering whether a statement was voluntary. And so when trickery gets to the point where it creates a coercive atmosphere that causes somebody's will to be overborne and confess when they didn't want to confess, that's what we're looking for here. This court has to make a determination of, did the police go too far in this circumstance? And here they did. So police are still going to be allowed to use trickery under the rule that we're proposing, or the analysis that we're asking this court to make in this particular case. Although I would like to point out that certain trickery, like false promises of leniency and false evidence ploys that took place here, are so highly coercive that Amicus and Amicus Innocence Project encourages this court to ban it altogether and to follow the trend that many states are taking right now. There are about 5 states that over the last years have moved to ban that type of police conduct in interrogation. So there's a certain type of conduct that is more coercive than others, and that conduct took place here.
What about the fact that the officers continually said, well, we don't control the sentencing decision. They, made the statement, but then they said, no, we don't. We don't have the final say on that. What do we do with that?
Yeah. So that doesn't take away from the fact that they did imply a promise. So the case law does not differentiate, and the science and research does not differentiate between a promise that's expressed or one that's implied. And so the fact that here the police sort of set Mr. Stewart up to say, you know, you're going to get 20 years if you don't talk, and that was an explicit thing that they said to him. Josh asked, how am I going to do 20 years to life? And the police officer said, because you're sitting here not saying nothing. And so the police officer is directly tying together the fact of his silence with a longer sentence. And then, of course, the police officers later, when Josh makes it clear to them that he believes that he's going to get 2, because he says to them, y'all talking about 2 or 3 years, right? The police say, oh, we're just giving you an example. So they do attempt at a time to say, we're just giving you an example. But then immediately after that, the police doubled down on the example that they gave him, making it even more comparable to the situation that he was in. And the police tell him, you know, this is just an example, but then they again make an implied promise of leniency by saying about this woman in a similar situation. They say, she said, this is what I did, I'm responsible for this, and that's what she got. She got 2 years. That's why we're here talking to you. What was Joshua Stewart responsible for? That is an implied promise to Joshua Stewart. And immediately after the police said that, he said, just driving. This is 2 hours after a coercive interrogation where he's degraded, manipulated, and bullied by police officers. They also told him that he will come out a winner if he tells the truth all the way through. Another lie. And Josh believed it, saying, so you're saying I'll come out a winner. His statement was directly linked to this promise of leniency and to these false evidence ploys, where the police said to him, we have you on video. This is an 18-year-old who has some, he was in an alternative school, didn't graduate from high school yet. He had just recovered from cancer. It's 3:40 in the morning, in the middle of the night. The interrogation lasts 3 hours. He hasn't been able to talk to his mother. The police officers are saying to him, just tell the truth. Just tell us what you did. It's okay if you were just there. They're lying to him all the way through. And Josh says, y'all are talking about 20 or 2. Who wouldn't take 2? This is a situation where there's really no question that there's a causal connection between the interrogation, the coercive interrogation that happened here, and his ultimate statement.
If we set aside the time frame that this took place and the language that was used and the lies, and we're just looking at this, if the officers had said, you know, there's an opportunity here, you know, and we can talk to you about what the prosecutor may do. We would talk to the prosecutor. We've seen them do these things before. You know, if you tell the truth, you know, there is that opportunity. If they used other language and gave the example of that other case where that co-defendant had received 2 years, you know, is there a way that they could have presented this where Mr. Stewart could have understood that they were not making a promise?
So if we remove everything that happened in this case and think about if that's the only thing that happened, that the cop said to him, you know, yes, we're going to talk to you, you're the prosecutor on your behalf, and if you cooperate, we can do that. That's allowed. The law says that broad statements that generally, you know, maybe if you cooperate, things might be okay. Broad statements like that with nothing else are considered okay. But the law also says that that has to be differentiated from assurances, whether explicit or implied, that a person's either their defense will be helped by cooperating or that their sentence will be less by telling on themselves.
So is it going from that broad statement to actually using the 2 years? And then when Mr. Stewart says back to them, so you're saying, you know, 2 years. He says that once, and then I think one time he says 2 or 3 years. When he relays that back to them, their response to him of, you know, we're not promising that, you know, we're just giving you an example. That wasn't enough because they opened the door to begin with?
It wasn't enough for a lot of reasons, but one of the reasons is because after they said this is just an example, they doubled down on it. So then they like reissued the promise again. And in People versus Conte, when this court was considering false promises of leniency, and that was a split opinion in many ways. But part of the analysis there was, what's the effect on the listener? What's the effect on the individual who's receiving this? And the court was clear that we have to look at the perception of the individual who was on the receiving end of that promise. And it was very clear from this record that even though the cops sort of did like a wink, wink, we're not really promising this, when they doubled down on it, there's no question that Josh believes that that's what's going to happen.
Thanks for bringing up Conte. Are you asking us to adopt the minority position in Conte?
I am asking this court to consider a combination type of a test that was considered in Conte, but specifically here to give direction to the trial court that when they're reviewing voluntariness under a totality of circumstances analysis, heavy weight has to be given to factors like false promises of leniency and false evidence ploys. And that's because of the scientific research and expert studies that we've seen that show how coercive those tactics are and how they significantly increase the risk of false confessions and wrongful convictions across the country. So it is a combination test of Conte, although it's not the exact combination test that the justices...
So would we have to be overruling Conte's majority opinion?
No, Your Honor, because Conte's majority opinion adopted the totality of circumstances test. So they adopted a totality of circumstances test, and here I'm asking the court to provide an analysis for Mr. Stewart under a totality of circumstances test, but to give direction there may be some factors that weigh more heavily than others to the trial court. And those factors are present in this case, again, and supported by the research in the amicus briefs.
Didn't the officer give the defendant a pretty accurate idea of how the criminal justice system works? Before they got into the example you're talking about, the officer says, I'm trying to find out the truth. That's my job, is to find out what happened, what led up to it, and what happened afterwards. What's the evidence? That's all I'm here. I don't send anybody to prison. I'll leave out some of his colorful language, but he says, I'm not the judge. I'm not the jury. I'm the guy that's supposed to find out what happened, and that's it. That's my job. And once I find out what happened, I'm done. My job is over. I give it to somebody else. You're facing the judicial system. Isn't that a pretty accurate description of the criminal justice, criminal procedure as it relates to how this is going to work?
I don't think I can agree that it's accurate, because when the police enter an interrogation room, they are taught and they are trained to get a confession. That is what they do.
I mean, that's obvious.
So
the question, well,
truth-seeking is different than, the cop is telling him, I'm here to find the truth, that's all I want to do, I have no skin in this game. But really, cops do have a skin in the game. And they are trying to get a confession every time they enter an interrogation room.
I mean, I guess I don't know that I agree with you on that. That seems like a pretty conclusory statement. They're there to get evidence. Depending on the case and depending on what information they have going into it, they might have a high degree of confidence that this individual is the one responsible for the crime, and in which case, yeah, they would be more aggressive maybe in trying to get the person to confess. There are probably other situations where they don't know if the person committed the crime, and they're trying to get information that would either help to determine whether the person is inculpated or exculpated, and so they can direct their energies and efforts elsewhere. So I'm not going to buy into the idea that every time they're there, even if they know the person's innocent, their job is to get a confession. I don't think that's routinely done. And so my question to you is much more mundane. Their job is to get evidence, right? To gather evidence, try to determine what happened. Do you disagree with that? That's not the police law enforcement function?
I believe that's one part of the function, but I also believe if they're following the Reed technique tells them to go in that room and get a statement. So I think that both things could be true.
Statement, again, they might want a statement from this person. It might be inculpatory, it might be exculpatory, but they're trying to get this person to tell them what they know to help advance the investigation. But the officers also said what the limits of their role is, right? They're not the judge, they're not the jury. I just find out what happened. That's what I do.
The police also told Mr. Stewart that nobody would see his statement except for his lawyer.
Nobody
So
what?
nobody
what?
would see his statement except for his lawyer. The police did not give Mr. Stewart accurate information about the justice system. They told him that it's okay if you were just there. That's the minimization technique that the American Psychological Association pointed out was problematic, and that increases the risk of false confessions, especially for young people. It's not okay if Josh was just there. We know that under the law. And so the police fed him misinformation about the law and about the facts and about the evidence they had against him in order to get him to make
What
a statement.
misinformation did they give him about the evidence? Said
They told him that there was video camera surveillance that showed he was at a scene. That's not true. They told him that there were witnesses against him that could identify him. That's not true.
Let's just talk about the video. How does it make it more likely that someone, or coerce someone to confess if you say you have a video?
I would encourage the court, there's a lot of study and analysis pointed out in the amicus pleadings, American Psychological Association and the Innocence Project, and the studies show that, for example, if I had told you, Justice Viviano, that you stole my pen, and you said, no, I didn't, but then I tell you that Justice Clement has said that you did steal my pen. Like, she's gonna say that you stole my pen, Justice Viviano, and don't worry about it because it's just a pen, and I can get another one, and it's fine, you're not gonna get in trouble. You are more likely to say, okay, yes, I took your pen, sorry about that. You are more likely to confess, and that has been repeated over and over again in scientific studies, and if you think about how that impacts somebody in an interrogation room, that is even more coercive and encourages people to confess when the police say, I have you on tape, and I have witnesses, and I have your cell phone records, you were there, and don't worry, it's okay if you were just there. And that's what happened to Mr. Stewart.
All right, thank you, counsel.
We used up all your time, but I do just real quickly want to switch over to the sentencing guideline piece. And I should have asked Ms. Young, but you're here, so I'll ask you. So right now we have a structure where with the sentencing guidelines, if one of the OVs is scored incorrectly, we have a process for that. If there's nothing in the sentence that anyone can point to that says this was unlawful, and we say, okay, but they still have to all go through the appeal process, what is going to be argued? What is going to be pointed out when we don't have all of the process that we have set up to protect the defendant in the sentencing scheme? What is that appeal going to look like? I'm having a hard time seeing all of those cases go to the Court of Appeals for them to say, you know, I don't see an abuse of discretion, so, you know, kind of why are all these cases coming to us?
One important process that we do not have in Michigan for imposition of a sentence within the guidelines is any sort of articulation of why a trial judge is giving that particular sentence. So Michigan has some of the widest sentencing guideline ranges in the country. Our ranges are not really ranges. They can range 60-some years sometimes in a case. In Mr. Stewart's case, they ranged 9 years. So he could have either gotten a 14-year sentence or a 25-year sentence. The trial court didn't have to say anything of why it was imposing either one. And so that's one part of the process that's lacking in Michigan, is we don't require any articulation to give anywhere within this range. But what it looks like of challenging an inside guideline sentence is challenges about the problems with Michigan's guidelines. Our guidelines were enacted in 1998 with absolutely zero oversight since that time. That should trouble us. It's not at all comparable to the federal system where they have robust sentencing commission review and oversight. They analyze data. They check to see if their guidelines actually do fulfill the purpose that they were set to achieve. We have none of that here.
And let's say we agree with you on that. That's not our place. That's for the legislature to say, you know, we've got to recognize and look at what other states are doing, what the federal system does, and you know, our ranges are too big. They can even say, you know, maybe we should have judges articulate where in that range a defendant is, you know, that minimum is placed. But for us to look at the appellate process, that's what I'm struggling with, is those aren't things that can be argued in every single case.
I think on the appellate process, the appellate court's looking to see, again, from the test in Steenhouse that was announced, is whether the sentence is proportionate to the seriousness of the matter, not whether it departs or adheres to the guidelines. So an appellate court is looking to see if a sentence is proportionate, does it take into account individual considerations and criminal background and the seriousness of the offense. In Michigan, our guidelines do not take into account mitigation or a lot of individual characteristics. So I think the challenges that an appellate court could see is exactly that.
Beyond the record, beyond the criminal record, which is...
Beyond the criminal record, exactly. My client was 18. He had a substance use order, or he, entered this treatment at this time, or this was his family and home environment that should be taken into account. There are a lot of circumstances that sentencing judges could take into account.
And maybe do currently take into account. They're just...
Sometimes they're presented, and sometimes they're presented and sometimes they're not. Sentencing proceedings in Michigan are very cursory most of the time and very quick. And part of that is probably because of the guideline system we have set up.
Okay, thank you very much.
Thank you.
Good afternoon again. Tim Boffman, Assistant Prosecuting Attorney representing Kim Worthy, the Wayne County Prosecutor. I really have little to add to what I have said in my brief. We've already talked about the sentencing issue. With regard to the confession, Conti is the law with regard to promises of leniency, that they're one factor that go into the totality of the circumstances. And I would say, as I believe Justice Viano has pointed out, there was no promise of leniency. The police clearly said, I'm not saying you're getting 2 years. I gave you an example of what happened, of what somebody did by taking their own path, by taking their own life in their own hands, and that was the outcome. And quoting again, we're not the judge, we're not the jury, we don't hand down sentencing. All we do is investigate crime. And when the defendant says, what do you want me to say? He said, I want you to, expletive, be honest. I want to know what Joshua Stewart did. That's what I want to know. So it's hardly encouraging him, just admit you did it, no matter whether it's true or not. Just tell me what you did. I want you to tell me what you did. Take control of your own life. Don't let somebody else control it. Tell me what you did, and you may come out better. You could come out a winner. He didn't say you will come out a winner. He said you could come out a winner. And frankly, he got convicted. He got a lengthy sentence within the guidelines, but he didn't get convicted of felony murder. And I think he didn't get convicted of felony murder because the jury saw the video. And they saw him saying, I didn't shoot anybody, I didn't have the gun, and I think the jury said he's not as culpable as the person who did the shooting. And he came out a winner in the sense that he did not get convicted of felony murder. And if you didn't have that statement, you've got him in the car, a guy shot in the back, he's in the car with the co-defendant who shot, with the items that were taken from the guy who shot in the back. Doesn't look good. This court isn't sitting as the trial judge to
Counsel,
make its
good morning.
decision as
Counsel,
to...
good afternoon. This is kind of the issue that I've always had with kind of these things, is that these interrogations are designed to get to the truth, right? That's the whole essence, is that they're designed to allow for the truth to kind of come forward. And I guess I'm going to ask you the age-old question, which kind of goes down to the distinction between getting to the truth through saying, look, we have your DNA. We have your blood. We have eyewitness identification. And distinguishing that between saying, look, you either confess now and you get 2 years, or you take your chances and you're going to get 20. One is basically, you can sometimes, as the Supreme Court has said, you can lie about the evidence that a person has against them, because that way that can trigger an emotional reaction as to, oh my God, they know what I may or may not have done. But there's a distinction between that and saying, hey, you can either take the 2 years or the 20 years. One is not truth-based. The other is more kind of coercive in terms of the overall consequence, isn't it?
Well, and that would go into a totality of review, right. And it's not what happened in this case. They did not promise him 2 years. In fact, they clearly said specifically, I'm not telling you you're going to get 2 years. That's not my job.
But it was suggested. They always say that. They always say, look, I can't guarantee, it's up to the prosecutor, but it's kind of implicit that that's kind of an
And
idea.
the current law is clear that suggestions that you'll talk to the prosecutor, if you tell the truth, this may be of aid to you in your case, are not coercive.
Right, I
They're
understand.
part of the totality and they're not coercive, and I don't think what happened here, in the context of what they said, we want you to tell what you did, take your life into your own hands, you could come out a winner. Somebody who did that came out with 2 years. We're not saying you're going to get 2 years. That doesn't strike me as a coercive interrogation or anything inappropriate. And as Your Honor indicated, there are cases you can say we have your DNA, we can say the co-defendant has turned on you, we can say you have a video seeing you at the scene. Now, I don't know about the example about Justice Viviano taking my pen. If you told me you had a video of me out in front of the place, or of a video of the incident happening in front of the house, I'd say great, because it's going to show I'm not there. I wouldn't say, gosh, then I give up, I was there. It doesn't, and the law is clear that it simply isn't considered coercive. It's a legitimate tactic, and I do not think
What about
the court.
the failure of the parent to be able to be present?
Pardon?
What about the failure to reach out to outside people?
The failure to reach out to outside people?
Yeah, like the parent.
Oh, his mother?
Yes.
Well, an adult has no right to their mother. I mean,
But in terms of-
nobody
I
who's being
understand that-
interrogated has the right to have somebody else in the room with them, other than asking for their attorney, which they were
But I guess-
advised of.
But I guess, what counsel is kind of talking about is that we're going to go back to that totality question, right? Is that we're looking at the time of day, we're looking at the duration, we're looking at the language that was ultimately used, we're looking about the promises that may or may not have been made, not saying that they were promises, but just
Sure.
the contention of what could possibly be present. And then you're putting into the fact that on top of which, I understand it's right there, but on top of which you have the lack of the parent, when we're looking at a totality, and especially with the language that was used, you'd have to say it was a pretty aggressive and pretty intensive interrogation.
Reasonably so, I think, but not one that made it coercive. And I just have to go back to no one is entitled to have somebody in the interrogation other than their attorney, which they can ask for and are told they can ask for, and can cut off question at any time. The age is some factor you can take into account. And I think if you, again, not acting as the trial judge yourself, but asking if Judge Kenny, with decades of experience, if you're left with a firm and definite conviction that he made a mistake in reviewing this record and finding the statement voluntary, I don't think there's any new rules that need to be developed here. Look at this interrogation and make that decision, and I think the answer is that Judge Kenny, you would not be left with the firm and definite conviction that he made a mistake in finding the statement voluntary.
Counsel, what are we to do about the scientific data about false confessions? I mean, we know a lot more than we did 50, 60 years ago on sort of how confessions work. We were presented with some data about DNA exonerations, non-DNA exonerations, where there were confessions in those cases. Do we just ignore that?
Well, I don't think the court can say that based on that data, it can exclude confessions that are taken consistent with the Constitution. And if this confession...
But does that impact our analysis on
I don't think it
whether they're
affects the analysis as to voluntariness. That people may give false confessions, and I don't think in this case that's something to worry about, particularly if you look at the remarks the defendant made at sentencing. This is not a false statement. He was the driver. He lamented in his confession how he had screwed up his life and let his mother down. He was the driver, but I didn't shoot anybody. We don't have a false confession here. And if you want to address those kind of things in an appropriate case, perhaps, but although again, I'd be happy to say that if it's a voluntary statement, it should come in. But in this case, I think we have a voluntary statement that Judge Kenny, at least, you shouldn't be left with a firm and definite conviction that he erred. Thank you very much.
Thank you. The case will be submitted.